Good afternoon and welcome to today's webinar, a civil justice review of the Supreme Court's October term 2022, sponsored by the Law and Economics Center at George Mason University's Antonin Scalia Law School. I'm Donald Kochan. I'm a professor at Scalia Law School, as well as the executive director of the Law and Economics Center. I'll be moderating today's debate and discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues facing judges and policymakers nationwide. Always it's centered around the belief that when judges, academics, and other policymakers better understand economics, they're more likely to make decisions that engage in rigorous analysis, and therefore are more likely to identify important issues that need to be addressed. Our commitment to the Law and Economics Center is to developing original high-quality law and economics research and educational programs like the one you're participating in today to further enhance economic understanding and to provide information that is useful in the legal and policy debates surrounding these issues. To all of you watching on the live stream and to our viewers on C-SPAN, we thank you all for joining us today to be part of this ongoing dialogue. Our panel of three experts today each come to the discussion with impressive backgrounds, litigating and analyzing issues before the United States Supreme Court. But so that we can reserve time for the substantive discussion, I'm only going to give very brief bios and leave the extensive summaries for your own investigation at the email that you received, the links in the email that you received, or by visiting the website where more information is available, masonlec.org. That's masonlec.org, where you can learn more about these panelists, as well as about all of the Law and Economics Center programming. Our distinguished panel today includes Erin Murphy, who's a partner at Clement and Murphy at PLLC, Andrew Pincus, who's a partner at Mayer Brown LLP, and Melissa Arbus, who's a partner at Latham and Watkins LLP. The panelists will go back and forth on about 6 cases, and then we will have some intra-panel discussion as well as audience Q&A at the end. If you have a question, please submit your questions using the Q&A box at the bottom of your screen, and please keep your questions brief so that they are suitable to answer in this virtual format. Please also identify yourself in the question. With that, I'm going to now turn it over to Erin Murphy, who's going to get us started with the first case for discussion. Erin.
Thank you, Professor, and thanks to everybody for joining us today. I'm going to kick things off with one of the bigger cases, probably biggest cases that came out at the very end of the term this year, which is 303 Creative versus Alanus. So this is a case arising out of Colorado's public accommodations law, which is a law that prohibits discrimination on a wide variety of bases, including sexual orientation. The law broadly defines public accommodation to encompass essentially any business that provides any kind of service to the public, and it doesn't have any provision allowing for an exemption on the basis of religious beliefs. As a result, this law and a few other laws that other states have that are similar in nature have led to a lot of disputes over the past few years involving whether people who provide principally various wedding-related services but object to same-sex marriage on religious grounds can be required to provide their services for a same-sex wedding. Some of you may recall the court confronted this issue a few terms back in a case called Masterpiece Cake Shop, which involved a business that provided custom cakes for weddings, and the custom cake maker was unwilling to provide them for same-sex weddings on the basis of his religious beliefs. The court didn't end up resolving the constitutional questions there. The arguments had been made that applying the law to compel him to make the cakes would violate his First Amendment free exercise and free speech rights. But the court instead resolved the case on a pretty narrow ground, finding that there had been actual overt discrimination by the state board on the basis of religion in the proceedings below. So this litigation really continued in the lower courts for several years, for the past several years. And the Supreme Court has had multiple chances to take it up, but had turned down several cases until this 303 Creative case came along last term. So 303 Creative is a custom website and graphic design business run by a woman named Lori Smith. Lori designs websites for all sorts of groups and causes, and she decided she wanted to expand her business to make custom wedding websites. But she's a devout Christian, and she's unwilling to design websites for same-sex weddings on the basis of her religious beliefs. Now, it was stipulated in this case by the parties on both sides that Ms. Smith would serve any customer regardless of their sexual orientation. So if someone asked her to design a website, say, promoting an animal rescue shelter or one of the other types of charitable organizations she'd done websites before, she'd say yes, regardless of how the customer identified. But she was unwilling to use her creative talents to create a website that expressed a message supporting same-sex marriage, regardless of who the actual customer was requesting that website to be made. It was pretty clear from the way Colorado had applied its public accommodations law in past cases that this was going to present a problem for her. So she brought this lawsuit arguing that to apply the law to force her to create wedding websites for same-sex marriages would violate both her free speech and her free exercise rights. She lost in the lower courts and the court granted review. But notably, while both the free speech and free exercise claim were in the case, the court decided to grant review only on the free speech claim. So while this certainly is a case with a huge overlay of religious liberty, and I think for many, many think of it as kind of a religion case, it actually was decided purely on free speech grounds. And 303 Creative ultimately ended up prevailing in a 6-3 decision. This was one of the cases that did divide along the kind of 6-3 conservative liberal divide of the court, with Justice Gorsuch writing for the court's more conservative members and Justice Sotomayor writing a dissent for the court's 3 more liberal members. It's also notably one of the fewer of the big cases that actually just had 2 opinions, just a majority and a dissent. As we may have opportunity to talk about, there's been a lot of separate writings throughout this term, but not in this case. And I think here, for the court, for both sides of the court, this case really came down to a matter of framing. As a general matter, the Supreme Court has long upheld public accommodation laws against a variety of challenges, but it also has a strain of cases in which it's repeatedly held that the First Amendment prohibits the use of public accommodation laws to compel people to engage in speech or expression with which they disagree. Some of you may recall from a couple decades back now, the Hurley case, where the court unanimously held that applying a public accommodations law to require private parade organizers to include a gay, lesbian, and bisexual group whose message they disagreed with in the parade would violate the organizers' First Amendment rights. In the Dale case, the Supreme Court held that applying a public accommodations law to require the Boy Scouts to reinstate a gay scoutmaster would violate their First Amendment rights. And the majority here really viewed this case as of a piece with Hurley and Dale. And I think that's in significant part because the court viewed this as a case in which it was clear that there actually was speech, that this was on the speech side of the First Amendment line, in part because there were some really critical stipulations in this case. The parties on both sides had stipulated not only that websites are a form of speech and expression, but that the websites that 303 Creative produces are expression on behalf not just of the customer, but of 303 Creative itself. And for the majority, once you have a business that's essentially in the business of using creative talents to engage in First Amendment protected activity, the Hurley and Dale cases compel the conclusion that you can't apply public accommodations law to compel someone to speak a message with which they disagree. Now, I'm not sure my fellow panelists may have different views. I'm not sure that the dissent actually disagrees with that proposition of law as a general matter. The dissent instead really viewed this as through a different framework and viewed this as this isn't a case about speech. It's really a case about conduct. This is a business that's providing a service. The speech of 303 Creative here is pretty incidental. It's principally the speech of the customer. And so really the debate here was about how to think about the case and less about, I'm not sure the dissent would really say, yes, you can compel the painter to paint a painting celebrating communism if they disagree with it, and all the various hypotheticals out there. The 2 last things I would just note before opening it up to Melissa and Andy. One is I think in the future, where do we go from here? There's difficult questions about what is and isn't speech, and there's going to be plenty of cases where that's going to be litigated. Is the custom cake baker engaged in First Amendment activity? What about the custom florist? What about whoever's designing, the tables at the wedding? There's been t-shirt cases, all sorts of different cases with tricky questions there. And 2, relatedly, part of why that's tricky is if you have a case that doesn't involve speech, but does involve sincere religious objections, then what happens? What happens is a free exercise matter. Does it violate the free exercise clause to compel someone to engage in some sort of activity that violates their religious beliefs. The court has sort of dodged that question, I think, in large part because it hasn't settled on what it wants to do with its free exercise jurisprudence, and in particular, the employment division versus Smith question. But, while this case helps take a lot of the cases, resolve a lot of them that do involve First Amendment speech activity, there's certainly going to still be litigation about the cases that don't.
Thank you, Erin. Andy or Melissa, do you have any comments or thoughts on this case?
Sure, I guess I'll start. I think it's concerning. I think we really have opened up a whole new avenue for challenging public accommodations laws. I mean, this is about weddings, but nothing restricts it to some company or service providers' objections about weddings. There could be all kinds of other objections, and certainly nothing restricts it to same-sex weddings. And I guess I disagree a little bit with Erin about where the dissent was. I think part of the dissent's argument was, this is about the product that you provide. You can certainly provide a product that says, my celebration is limited to opposite-sex marriage, or I'm celebrating opposite-sex marriages. If you say that, if that's a constant characteristic of your websites, then that's fine. But the problem here is in the provision of this kind of generalized services. And we've already seen lots of cases in the lower courts and even just people pivoting off of this decision in terms of calligraphers and florists and musicians and bakers and dancers. And again, I think it is very concerning in terms of the we don't serve you opportunities that it opens up.
Yeah, I agree on the one thing I was going to add, which is probably a good transition to the next case we're going to talk about. But in terms of consequences for discrimination laws more generally, I'm going to talk about the affirmative action cases next. And I think in terms of the breadth of the decision, it'll be interesting to see what implications it might have and what applicability it may have to discrimination laws more generally in every which direction, especially if speech is interpreted broadly to include a significant number of businesses that touch on speech issues. So I think, Erin, you're right. This is one of the few decisions that only had 2 opinions that came out of it. And I think, one of the products of that is it's a pretty broad decision, and, we'll see what the implications are. I imagine for years to come on this one. I will use that as an opportunity to segue into the affirmative action cases, which is the next set of cases we were going to cover, or that I'm going to cover. This is also one of the really big ones of the term. Some may say the most important decision, but I'll let folks decide what they think on it. The cases were argued way back in November. They were decided on the penultimate day of the term on June 29th. And there were 2 cases. One came out of Harvard, the other one came out of UNC. Both schools use race as one of many plus factors in a holistic admissions policy for the purpose of achieving education diversity. Those policies were challenged, and they were challenged under the Equal Protection Clause for UNC and under Title VI for both schools. After a trial, the lower courts upheld both admissions policies as satisfying strict scrutiny under the Supreme Court's then controlling decision in Grutter. And the real critical question before the court was whether or not the court was going to adhere to Grutter or overrule it. Ultimately, the answer was the latter. The court did, I would say, effectively overrule Grutter, even though if you look at the majority opinion, it doesn't explicitly say that. This was another one of them towards the end of the term that was a 6-3 decision along the more traditional ideological lines. There were more than 2 opinions in this one. I won't spend a ton of time on the other decisions, maybe a little bit, but we're talking well over 200 pages of decisions in this case. So it takes a little while to get through. To summarize it, the majority, and the Chief Justice wrote the majority decision, basically articulated a 3-part test for assessing the constitutionality of a race-conscious admissions program. The first one is the program has to comply with strict scrutiny, and that sort of follows from prior cases, although maybe with a little bit more of a twist. The second is the program can never use race as a stereotype or a negative. And the third is that the program must have an end. So on strict scrutiny, the court found that the programs did not satisfy strict scrutiny for really two different reasons. One is the compelling interest that was identified was educational diversity, which had been blessed, so to speak, in Grutter. But according to the court here, when the schools were talking about educational diversity and sort of the specifics of that, it started to the court to feel very amorphous. This was something that really couldn't be measured by a court. It wasn't concrete enough for a court to review. So educational diversity didn't satisfy the compelling interest standard. It was also not narrowly tailored, according to the court, to achieve that interest. According to the court, the schools didn't really provide a meaningful connection between that interest and the programs. A couple of things they pointed to, but one was how the different races were grouped. The idea that all Asians were grouped together was an example that featured prominently in the decision. And then in addition to strict scrutiny on the second point, the stereotyping, the court basically said that, admissions are a zero-sum game. So if it's a positive for some, it's a negative for others. And one of the quotes that jumped out to me from this part of the decision was the idea that an inherent benefit in race qua race, in race for a race's sake, according to the court, is something that you could not have. And then finally, the no endpoint. So this came from Grutter. At the end of the Grutter decision, there was language in there talking essentially about, some might call it a 25-year sunset. The court in Grutter had said 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. And so according to the majority, the admissions policy, in order to be, potentially appropriate under the Equal Protection Clause, it needs to have a definitive or logical endpoint. And the parties had really not identified or tried to even suggest that there would be one. And so Grutter, I think, effectively is no longer. It is interesting that the majority opinion doesn't say that in so many words, but it is hard to see how any policy or any consideration of race that decides to admit one applicant over another could survive the court's analysis. Justice Thomas in his concurrence was much more explicit about it. And then ultimately, if you look at the majority decision, as I said, the chief wrote it. And another quote that jumps out and is sort of reminiscent about something he wrote in an earlier case was that eliminating racial discrimination means eliminating all of it. And in a prior case called Parents Involved back in 2007, in a plurality decision, he has sort of the famous quote, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." And so that's really the bottom line that comes out of the majority decision here. Now, there is a paragraph towards the end, it's on page 39 of the decision, that I think we're going to see a lot of litigation about because it leaves open certain practices. The court explicitly left open the idea that universities can consider an applicant's lived experience as informed by race. Now, this means you can't consider an applicant's race in and of itself, but you can consider certain personal qualities, experiences, skills that may be informed by a number of different things, including race. But right after saying that, the court was very careful to say that you can't do indirectly what the court just said you can't do directly, that universities may not simply establish through application essays or other means the regime that we hold unlawful today. And the court also left untouched race-neutral mechanisms for achieving diversity, such as giving preferences to first-generation college applicants, those who speak multiple language, and those from lower socioeconomic backgrounds. So like I said, there's a lot of different decisions. I won't go into all of them, but there were 3 concurrences, there were 2 dissents. There's a lot baked in there. Let me just focus on a couple takeaways and then I'll open it up for others. I mean, one, within college admissions, in some ways the takeaway is pretty clear. To a point at least, any decision to admit one applicant over another in a zero-sum context can't be based on the applicant's race. Now, I say to a point because there's a footnote that suggests maybe there's a possible exception for military institutions. So, that may be another case that we'll see soon. But I think there'll still be continued litigation, like I said, about that paragraph on page 39 rather, whether really decisions are being made based on lived experiences or whether that's sort of serving as a proxy for race. This won't be a huge change for public universities in some states where state law already prohibited race-conscious admissions policies, but for private universities in those states and universities, public and private, in other states, I think we'll see significant change. I think we'll also see some impact outside college admissions. Title VI, I mentioned earlier, that prohibits discrimination in federally funded programs. The majority decision applies the same rule for Title VI as it does for the Equal Protection Clause, so there'll be a very direct impact there. But Justice Gorsuch also had a concurrence in which he said that the analysis should actually be different for Title VI. It should just be a question of statutory interpretation, but that interpretation should look the same as the Title VII interpretation in a case called Bostock that he decided fairly recently. And in some ways, that's a little bit more absolute. And so I think the other sort of outside college admission potential consequences in the employment context. Even though this decision doesn't explicitly change the law in that area, there is a real possibility that courts are going to look to this decision in looking at Title VII cases, looking at affirmative action policies, looking at things like DEI initiatives. And then I think in contracting more generally, there's a statute called 1981 where, again, it doesn't directly apply here, but I think it will not be surprising to see courts starting to look in this direction in interpreting the case law in other areas. So I think there will be a lot more litigation to come on this issue, both within the context of universities and far beyond that. But I'll leave it at that, and I'm curious to see if others have thoughts.
Erin or Andy, any thoughts?
Yeah, I'll say, I mean, I think for anybody who's been sort of following this area, this decision was not a huge surprise, as Melissa says. I mean, particularly if you think of the justices in the center of the court right now as the Chief Justice and Justice Kavanaugh. This has been a project of the Chief Justice's for quite some time. It was not surprising to see him write the majority opinion here, and I do think it's as someone who's kind of a connoisseur of chief opinions, I think it's kind of one for the books. So I commend it to folks. It's just a very well-written opinion, regardless of what you think about the outcome. I agree with Melissa that this is the beginning, not the end of litigation in this area. And what will be interesting is I think for a long time, a lot of in the schools, because of the overshadowing of Grutter, there just wasn't a lot of looking behind what schools are doing. And I think the way the kind of final paragraph and what it is getting at, that you can't be using, essentially using race as a proxy via essays and such going forward, is really going to have to lead to cases where we're going to see real discovery and looking at, okay, does it turn out that you admit students on precisely the same ultimate breakdown, or you admit students kind of anytime a student of a certain race mentions their race in an essay, and all of that's just harder. I think schools will understand at this point, you can't kind of overtly say you have policies that encourage what the Supreme Court has now said you can't do, but many schools have already made clear that they intend to figure out policies to try to get to the same results. And that just opens up to a lot more looking behind that, looking at discovery, looking at how these policies and practices actually work, which has been happening more in the employment context for quite some time. But I think, as Melissa said, we may see it in the employment context and sort of some, in the past, it's been in a little more traditional conceptions of discrimination on the basis of race. And here, I think we'll start seeing it more in the context of efforts to kind of promote diversity within the workplace. So again, certainly a tremendously important decision, but really the beginning, not the end of, I think, a lot of litigation in this area.
Yeah, I completely agree with Erin. I think this is the beginning. And I think the other question that we really don't know the answer to is what does this mean for programs that are designed to lead to a diverse workforce or a diverse student body, but that don't use race as a criteria? Maybe a program that uses, for example, are you the first in your family to go to college, or other kinds of criteria. There's a case working its way up right now to the court involving a selective high school in Virginia, in which the criteria used are not race-based, but the argument is that they were adopted to achieve a diverse end, and for that reason are impermissible. So that's, I think, going to be quite an interesting question. And obviously, if that's true, that's really going to limit the ability of employers, schools, anybody to achieve a diverse workforce. But maybe with that, I'll transition to the case that I'm talking about. You heard from my colleagues about two cases where the law changed pretty dramatically. Mine is sort of the dog that didn't bark. Moore v. Harper, the so-called independent state legislature doctrine case, it arises under the elections clause of the Constitution, which requires, quote, the legislature of each state to prescribe the rules governing federal elections. And the question is whether that clause means that state legislatures have the authorities to set the rules for federal elections free from any restrictions that might be imposed on them under state law, such as state constitutions. The case arose from North Carolina. The state Supreme Court invalidated the legislature's districting plan based on a clause in the state constitution. And the argument was the state constitution can't really restrict what the legislature does. The legislature has free reign. Sort of the other backdrop of the case was another provision of the Constitution, the presidential elector clause, that says each state shall appoint in such a manner as the legislature thereof may direct a number of electors, blah, blah, blah. So the question is, the sort of lurking question was, well, if the elections clause gives the legislature plenary power, what does that mean for the presidential elector clause? And lots of concern about the 2020 election and the litigation from that, and then the 2024 election and what it might mean. There were various standards advanced in the case. Let me sort of tick through them. One is the legislature can do whatever. Nothing in the state constitution is binding. A second was the legislature is bound by procedural requirements. You know, the majority required for legislative action. The governor has to sign a bill in order for it to become law, but not substantive restrictions in the state constitution. Third, the legislature is bound by the state constitution, but there may be a little bit of federal oversight of how the state supreme highest courts interpret the Constitution. And then finally, no federal role at all. And the court, a 6-3 majority, a pick choice number 3. It was 6-3, but not the usual 6-3 vote. The majority opinion was written by the Chief Justice, and he was joined by Justices Barrett and Kavanaugh, and also by the 3 more liberal justices, Justice Sotomayor, Justice Kagan, and Justice Jackson. The first question the court had to address is this case moot? Because in the interim, the North Carolina had an election. The makeup of the state Supreme Court had changed. And the Supreme Court had issued a decision essentially rejecting the interpretation of the new North Carolina Constitution that was at issue in Moore. The majority said no. The 3 dissenters rejected that view, Justices Thomas, Gorsuch, and Alito. Justices Thomas and Gorsuch went on to disagree with the majority on the merits, but Justice Alito didn't join that part of the opinion. So just to talk a little bit about the majority's decision, the court really relied on, I guess, 3 different factors. First of all, it said judicial review was an established principle at the framing, and nothing in the elections clause excluded judicial review. Then it looked at its prior decisions, some older cases, but also the pretty recent decision upholding the amendment to the Arizona Constitution that gave redistricting authority to a commission rather than the state legislature. Interestingly enough, that was a decision in which the Chief Justice wrote a pretty impassioned dissent. But in this case, he took that as precedent and relied on it for his decision. And then the court looked at historical practice. The state constitutions of the framing had limits. So did the state constitutions under the Articles of Confederation. And there was sort of nothing in the elections clause that indicated an intent to override or prevent those kinds of restrictions. And then the court said, it's hard to imagine that the procedural requirements of the state constitution don't apply. And once you've sort of gone down that road, is there really any basis for the procedural substance distinction? So the broadest arguments were rejected, but the court said, looking at other areas of the law, it says it said, just to quote, there are other areas of where the exercise of federal authority or the vindication of federal rights implicates question of state law. We have an obligation, the court said, to ensure state court interpretations of that law do not evade federal law. For example, in the property context, although obviously state law defines property rights, the court has said if a state court dramatically revamps state property law, we're going to look at that to see whether it might constitute a taking. We're not going to just take state law where it was. So those cases, the court said, indicated that in this context, there should be a similar rule. And the court looked back to Bush v. Gore, not an opinion that gets cited very frequently after its enactment, that addressed whether the Florida court, some justices, although the court didn't, address whether Florida Supreme Court had exceeded the bounds of judicial review in that case. And Chief Justice Rehnquist sort of noted the deference to state courts, but cited these other areas. And his standard was, we won't give an effect to an interpretation by a state Supreme Court that impermissibly distorted the state law beyond what a fair reading required. So that was sort of something that the Chief Justice, this current Chief Justice, sort of took as a standard. He said, we don't have to address that here. Nobody asked the court to look at the state court's construction of the state constitution and see whether it fell outside the bounds of judicial review. I think it's sort of interesting that some of the reaction to this case has been great concern about the court sort of retaining this last bit of authority, but it really does reflect a principle that the courts applied not just in the property context, in the takings context, in determining for itself whether a state court decision rests on independent and adequate state grounds and therefore isn't subject to judicial review. So it really, if you look at the range of Supreme Court doctrine, it's not really an unusual standard. And of course, how the court applies it here will affect those other areas. And it seems to me they're going to be a limit on the extent to which the court is willing to second guess state court interpretations of the state law in the election context, because they could have ramifications for the stability of property law or contract law. But I'm interested in what my colleagues might think.
Melissa, any thoughts?
I was just going to say, I remember from the argument in this one, I think it was Justice Kagan who, when they were going back and forth on what the standard should be and what the standard might mean, said something along the lines of like, who hasn't written a dissent saying, you know, the majority completely misinterprets what the statute says. It's not a fair reading. And so I think it's another one of those. I think you're right that it's a standard that crosses over. But it's, you know, sometimes it's in the eye of the beholder. So it'll be interesting to see how it gets.
Erin.
Yeah, I'll just, you know, taking a step back. I mean, I think this is, this case really was in, everybody wants to focus on kind of, you take the cases that came out 6-3 and say those were the big cases and therefore the court was 6-3 in all the cases. And this just, to me, really undermines that narrative completely. You know, this is a huge case. And if it had come out a different 6-3 with a different result, it would be right at the top of everybody saying this is the biggest, one of the biggest cases of the term. And, you know, because it didn't come out that way and doesn't fit that narrative, people kind of put it by the wayside. I think it's really important to think about all the big cases that came out this term. And this is certainly one of a couple that surprised, yeah. I mean, I think by the time of argument, people had a sense where it was going, but certainly there was a lot of talk at the beginning of the term about this being a case that, you know, that could be a 6-3 huge, as Andy said, movement of the law in a particular direction. Instead, if anything, you see the Chief Justice kind of aggressively holding together a majority with liberal justices in a case that really probably could pretty easily have been kicked on mootness grounds. So just an interesting case, both in terms of just the fascinating issue underlying it, but also for those who are thinking about how to trying to process this court from a bigger picture perspective of sort of where it really is across the board.
Great, and we'll turn it over to Erin to get us started on our second round. And each of the panelists will take just a little bit of a shorter period of time, I think, to summarize these next three cases in light of our time constraints. But we're excited to learn about three more key cases. So Erin, go ahead and get us started.
Sure, I'll kick us off with National Pork Producers Council versus Ross, which I think is fair to say is another one of the, really, this is one of the bigger surprises of the term, probably. This is a Dormant Commerce Clause case. And for those of you who follow the court's Dormant Commerce Clause jurisprudence, you probably know it's a little bit of a mess, in part because there's multiple justices who don't think there is such a thing as the Dormant Commerce Clause, and even those who do aren't always on the same page about it. But the court did reinforce the existence of the doctrine a few terms ago in a case called Tennessee Wine, and it looked like they were poised to breathe some life into it here again. This case involved principally what's known as the extraterritorial doctrine of the Dormant Commerce Clause, which basically constrains the degree to which one state can regulate either directly conduct in another state or in a manner that directly impacts conduct that takes place entirely in another state. The case involved a California law that regulates the sale of pork in California. Essentially, the law prohibited pork from being sold in California unless the sow from which it came was raised and housed in compliance with a whole bunch of complex regulations, which had a huge impact on the rest of the country because while California is a major consumer of pork, it accounts for about 13% of the national market. It produces almost none and imports 99.8% of the pork it consumes. So as a practical matter, we're talking about a law that had the effect of forcing all the farmers who raise sows in many other states throughout the country to comply with regulations that don't exist and in some instances even conflicted with laws in those other states. The law had been upheld by the Ninth Circuit in a decision that essentially declared the Supreme Court's extraterritoriality cases largely defunct. So it looked like a case the court was taking to reverse. Instead, it ended up affirming. And while the vote count is like very complex here, you kind of got different people disagreeing on or agreeing on various different bottom lines for completely different legal reasons. There's one really big takeaway and then sort of a secondary one. The first is the court unanimously agreed that, that laws that have the effect of regulating conduct in other states are not subject to the virtually per se unconstitutional rule that applies in the Dormant Commerce Clause context. And it basically said, when you're talking about laws that have extraterritorial effects outside the state, unless they are actually discriminating against interstate commerce, that's kind of the lens through which you're going to have to view a challenge to those types of laws. You then had a 5-4 decision on the second piece of the case, which involved a pike balancing claim that was arguing that the burdens this law imposed on interstate commerce just vastly outweighed whatever benefit the law provided to California and its residents. On that, you had another one of the more unusual lineups this term. The bottom line, Justice Gorsuch authored the opinion. The bottom line was joined by Justice Thomas, Sotomayor, Kagan, and Barrett rejecting the pike claim, with the dissenting justices here being just the Chief Justice, writing for Justices Alito, Kavanaugh, and Justice Jackson. And so the court concluded, the majority concluded that the pike claim likewise couldn't go forward. So this is a pretty bad decision all around for those of you who, like I do a lot of Dormant Commerce Clause cases. But I will note a couple of quick silver linings and then, hear what Andy and Melissa have to say. One, I mean, in this realm, a silver lining is the mere fact that the court didn't throw out the Dormant Commerce Clause entirely, because there are some justices who want to do that, but it looks like there's not a majority of the court at this point that wants to do that. Two, that there was not actually, while the majority of the court rejected this pike claim, a majority of the court reaffirmed the notion that there are such a thing as pike claims and that they can exist. And because Justices Sotomayor and Kagan wrote separately to say, we're not with the justices who've kind of would get rid of these claims. We just think this one doesn't succeed. Now, exactly what pike claim does succeed, if this one doesn't, even get past a motion to dismiss, is pretty hard to fathom, but at least it's not dead. And then the third thing, which I actually, to me is the really important and really interesting piece of this, is this case was not an ideal extraterritoriality case because, as I said, it was a law that involved extraterritorial effects. It was regulating the conduct outside, it was regulating the kind of inside California of selling pork inside California. It didn't reach out and find the people who were raising the sows in another state. And that seemed to matter to the court because the Justice Gorsuch's opinion did go out of its way to say this wasn't a law directly regulating conduct that took place in another state. And he indicated that while I think in his view, the restrictions don't necessarily come from the Dormant Commerce Clause, that there are sort of horizontal separation of powers concerns, as he put it, with one state regulating conduct that takes place in another state, and basically left open the idea that when you have that kind of direct regulation, which there are some laws out there in some cases I'm dealing with that really do involve that you may have a different analysis. So not good news for the Dormant Commerce Clause fans out there, but maybe not all hope is 100% lost.
Thank you, Erin. And cognizant of time, I think we'll get through each of the summaries first and then see if the panelists want to reply to each other at the end of each of the three. So Melissa, why don't you take us through to the next case?
Yes, I'm happy to. So the next one is Mallory versus Norfolk Southern Railway. I feel like I'm echoing Erin. This was also, at least for me, a pretty huge surprise of the term. I was going to say the most surprising case, but when I think about it, that might not be true. But this one kind of shocked me, even after argument, surprised me. So this is a personal jurisdiction case. And just to provide a minute of background, for in recent years, the court has kind of been cutting back, so to speak, on the scope of personal jurisdiction, especially when it comes to corporations. And so in a couple of cases, there's an area called general jurisdiction, and it's basically when you can sue a person or a company in one state when the underlying acts that led to the lawsuit have nothing to do with that state. And the answer out of these cases was that for a company, you can only sue them, they're only quote unquote at home in two places, where they're incorporated and where their principal place of business is. And so that really did limit the number of states in which a corporation could be sued, at least when it had nothing to do with the state otherwise. So this case involved a Pennsylvania statute that's pretty unique, that says basically when you register to do business in Pennsylvania, you can be sued in courts in Pennsylvania for any cause of action, regardless of the relationship to the state. And so this lawsuit was brought in Pennsylvania against the railroad. It was a FELA claim by an employee who did not live in Pennsylvania, was not injured in Pennsylvania, and Norfolk Southern is not incorporated and does not have its principal place of business in Pennsylvania. And so the defendant argued that there's no personal jurisdiction over us in Pennsylvania in this lawsuit. And the question before the courts was whether or not the Pennsylvania statute basically saying otherwise was constitutional. And so it got litigated up to the Pennsylvania Supreme Court, and the Pennsylvania Supreme Court said that it does not violate, or rather that the statute does violate due process. And it said, looking back at Supreme Court cases, there was a case from 1917 called Pennsylvania Fire that had a sort of similar state statute, semi-similar facts. And the court looked at that case and said, yeah, sure, but a lot has happened since 1917. The court decided this international shoot case that really kind of changed personal jurisdiction law. And so the court has effectively, if not explicitly, overruled Pennsylvania Fire. And under the more recent cases, we think there's a due process problem here. And so the case went up to the court in that posture. And like I said, listening to argument and otherwise, I thought maybe there would be a couple justices who thought that this was all fine and well. I did not think there would be a majority, but there was. So this was a 5-4 decision. And to Erin's point, this is also one of those decisions that did not at all break down among, on ideological lines. It was, a pretty fun lineup, so to speak. So, Justice Gorsuch wrote the majority, and he was joined by Justice Thomas, Justice Sotomayor, Justice Jackson, and Justice Alito. Pause there for a second to take it in. The dissent was written by Justice Barrett, and she was joined by the Chief, by Justice Kagan, and Justice Kavanaugh. So that is a, needless to say, unique lineup. You guys can correct me if I'm wrong. I'm not sure I've seen that before. I'm not sure we will necessarily see it again. Who knows? But it was really interesting to see. And what the majority basically said is, yes, that 1917 decision in Pennsylvania Fire still controls. We never overruled it. And yes, I know we have this whole separate line of jurisprudence under international shoe that has to do, with minimum contacts and all of that. But that's just another way to exercise personal jurisdiction. What Pennsylvania has done here is basically allowed corporations to consent to personal jurisdiction. That's something you can do. And so by deciding to register to do business in Pennsylvania, with this law on the books, that effectively they've consented to be sued there. And the court also said, to the Pennsylvania Supreme Court, like, listen, until we actually overrule our cases, lower courts don't get to do that for us, which is sort of a theme you sometimes see in Supreme Court cases where lower courts, seem to see the writing on the wall. The court sometimes comes in and says, don't get ahead of us on that. The other piece of the decision, and this came out a lot at argument, was the idea that, corporations maybe shouldn't be treated different than individuals. And so back in 1990, there was a decision out of the court that basically reaffirmed something called tag jurisdiction. So you could be in a state that has nothing to do with you. If you're served there, then you can exercise personal jurisdiction over you there. And so it came up at argument. And I think the idea was that if that's fine for individuals, why should corporations be treated any differently in that respect? And then the final piece, and I'm going to talk a little bit more about this because I think this is an important part, is the majority rejected the had extensive contacts with Pennsylvania, did a lot of business there. And so actually inserted a chart that showed a graphic showing the extensive contacts within the state. The biggie is a concurrence by Justice Alito, where he agreed that there was no due process problem, but said, I think there's probably a dormant commerce clause problem with this statute applied on these particular facts where there's no relationship to the state. And in a footnote in the majority said, listen, this wasn't raised, an issue for another day. The dissent, for its part, said this is a complete end run around the decisions we've been deciding under general jurisdiction. And I know you call this consent, but it's not really consent in the way that you think of it. And so there's a lot of takeaways here. I'm going to try to be brief because I know we're short on time. Number one is, what's going to happen with the dormant commerce clause issue? So it's fine to say that the statute survives and isn't a due process problem, but if it's a dormant commerce clause problem, then, we're going to kind of end up in the same place after that issue is litigated. And so I think that is the obvious next question, and we'll see how it turns out. The second piece is, the focus on the substantial activity in the state. It's not totally clear to me if that is a necessary part of the majority's analysis, but it's in there. And so it may be that businesses that have less contact with the particular state maybe still have a problem even in Pennsylvania. And then the final thing is you need state law for this to work. So consent jurisdiction only works if there's a state statute that, provides a similar vehicle as Pennsylvania does. And Pennsylvania is unique in that respect. I think there's maybe 2 or 3 other jurisdictions that at least courts have interpreted to apply similarly. And we'll see if other states follow suit. That's sort of the big question. And there's a fair amount of political reasons not to do so, but I think at least New York has something, that just got through the legislature that maybe is on the governor's desk, but I think had been vetoed before. So we'll kind of see if any other states get on board with this approach. So this is another one where I'm going to end by saying there's going to be more litigation, and it's not clear to me, this either is a huge case or maybe it just ends up not being that big of a deal because it gets narrowed or maybe invalidated for other reasons.
Well, it certainly throws civil procedure professors for a loop as well as they begin the fall semester. And admin law professors too are going to have to adapt quite significantly. And Andy's going to take us through some of the key administrative law cases here to close us out.
Yeah, thanks. I think for anyone who's watching, and even for people who aren't watching, we're in the middle of a revolution in administrative law, in the rules governing the structure and powers of federal agencies. A majority of the justices clearly don't like the status quo and want to rein in what agencies can do, and they're doing it in multiple ways. Last term, we had the major questions doctrine, the idea that clear congressional authorization is needed in cases where the history and breadth of the authority that the agency has asserted and the economic and political significance of the assertion provide a reason to hesitate before concluding that Congress meant to confer such authority. So clear congressional authorization needed. And the court sort of followed through on that this term in Biden against Texas, the case involving the Biden administration student loan program. That would have canceled $430 billion in student loan principal, and probably not surprisingly, the Chief Justice, writing for 6 justices, and this was a typical, a conventional, I guess we can call it, 6-3 split, held that the statute didn't authorize the program, and also that it flunked the major question doctrine requirement. So the interesting thing about that case is a debate about the sort of status of the major question doctrine. Justice Kagan wrote a pretty vigorous dissent saying You people all say you're textualists, but what's the textualist basis for the major question doctrine? Seems like a made up judicial rule. And Justice Barrett wrote a concurring opinion saying, well, if this was a sort of a canon of construction, maybe you'd be right. But the way I view this is as an interpretive principle. We're looking at the context and putting the plain language in context. And that's really what the major question doctrine is doing. So maybe for statutory construction professors, something interesting there. I think the other really interesting thing about what the court is doing is that it's moving into a new area of administrative authority, administrative agency adjudication. If you think about the federal agencies that have enforcement power, the SEC, the FTC, all the whole alphabet soup of agencies, they typically have two ways they can exercise that enforcement power. They can go to court, bring a civil lawsuit, or they can use their internal administrative law judge structure and get an administrative agency determination. That's a trial before the ALJ. The decision then goes to the head of the agency or the commission for a final decision, and then that's reviewable in court. And not surprisingly, some agencies like to use that internal agency process rather than going to court. And in the past, it's been hard to mount constitutional challenges to that process because the old, pretty settled view was that the target of the agency enforcement action had to go through the process, get an adverse decision, and could finally raise the constitutional challenges on judicial review. And most regulated people and entities don't like to get adverse decisions from their agencies. Most of those cases get settled. And so there really wasn't a lot of litigation about the constitutional limits. But that's going to change significantly after this term because in a case called Axon against FTC, the court said, if you've got a certain kind of constitutional challenge, at least, you don't have to go through the process. If the agency has started to come after you, you can go right to court and you can bring your constitutional claim in court. You can seek an injunction to stop the agency from proceeding, and you'll get one if your constitutional claim succeeds. Axon was an antitrust review of transactions by the FTC. It went through the Ninth Circuit, which said, applied the old rule and said, sorry, you can't bring that challenge now. You've got to wait till your administrative agency process is complete. But there was another case, SEC versus Kochan, an enforcement action against an accountant, where the Fifth Circuit decided, yes, you can bring this parallel challenge. They went to the court and the court unanimously said, if your constitutional claim doesn't target a substantive decision, if it challenges the structure or the existence of the agency, or that the agency is wielding authority unconstitutionally in a broad swath of decisions, you can go right to court. So that clearly means we're going to see many more of these challenges that we saw before. But to me, particularly interesting was Justice Thomas's concurring opinion. He obviously agreed with the majority, but he questioned the basic idea of federal agency adjudicatory authority. He said, I have grave doubts about the propriety of Congress vesting administrative agencies with this authority and only deferential judicial review on the back end, at least where the agency adjudication affects what he termed core private rights, such as imposing fines and probably the ability to bar an individual from participating in his or her field of endeavor. And right on cue, the court granted a case for next term called SEC v. Jarkissi, which essentially tees up these issues. It's another SEC enforcement action undertaken through the administrative process, a charge of securities fraud, $1 million fine, more or less. Mr. Jarkissi barred from the securities business, and the Fifth Circuit held there were 3 separate constitutional defects in the SEC's process. First of all, it held that Mr. Jarkissi had a jury trial right because the 10b-5 securities fraud claim was analogous to common law fraud, and obviously no juries in the administrative process. Second, it held that the statute didn't have any guidance for the agency to decide when it should go to court and when it should use its internal process. That, the court said, was an unconstitutional delegation. And finally, the court said the restrictions on removals of ALJs, the fact that administrative law judges have their own protections against removal except for certain kinds of cause, and then the SEC commissioners who supervise them also can't be removed by the president except for cause, violated Article 2's requirements that the president have control over the exercise of executive power. So just after Justice Thomas's concurrence, the jury trial issue tees up his private rights question pretty clearly. And we have two other bases for challenging these internal administrative agency processes. And I think in the wings, we probably have some due process challenges. The SEC initiates an enforcement action, and then it's the judge at the end. Is that a due process problem? In the past, courts have said no, but we're in a new era. If the president has plenary removal authority over the people who are deciding these adjudications, is that a due process fairness problem? I think we're going to see a lot of these challenges. So let me stop there because let me make one comment about my colleagues' cases because I can't resist. I think both Mallory and the Port case show a majority very willing to rethink what some people might have thought were settled principles about the Commerce Clause and the due process limits on personal jurisdiction. A majority that's willing to rethink them and decide the cases in a way that is going to create a whole heck of a lot of litigation before these issues are ironed out. They're not really worried that much about stability of the law in this area. And the third point I'd make is we'll never know, but my intuition is Justice Jackson made a big difference in these cases. I really wonder whether Justice Breyer would have voted to unsettle personal jurisdiction jurisprudence the way the majority decision does. And I really wonder where he would have been on the Port case.
Erin and Melissa, we have time for 1 minute each on the other cases that we just discussed in the second round.
I will be very fast. I was just going to make an observation that I think one of the other takeaways from this term is, I feel like a few years ago, there was a presumption that the court was particularly friendly to business. And I don't think that quite holds anymore. I think last term showed that a little bit. I think this term kind of doubled down on that a bit. Not to say that it's unfriendly to business, but I think if you go in with an assumption that the court's going to always come out on one side of those issues, I think that misses sort of the nuance that exists on the court today. And I think the case that Erin talked about and I talked about are probably prime examples of that.
I'd just make one quick observation, which is, there's a tendency to want to take, you've got the ideological 6-3 divide, and then you've got sort of like a dogmatic, pragmatic divide that you see, and you see that in the Dormant Commerce Clause context, where I think the dissenters really are, who you may think of as a little bit more pragmatic, but then Mallory even throws that for a loop. And so, I guess it just comes back to my broader point of, I think there's just still a lot to learn about this particular set of 9 justices and how they approach issues, both the big social issues and the issues that, may not get as much attention, but matter a lot in the actual day-to-day lives of many of the clients we represent, and many of you. And so there's just, plenty to tune in for.
As with every active term, it's difficult to get through all the material, or at least some of even the highlights in just an hour, but we do want to be cognizant of our viewers' time and keep this as a hard stop at 1 o'clock. So unfortunately, we won't get to the questions, but thank you, audience, for some great questions that were submitted. I'd like to spend our last 90 seconds with a lightning round of predictions for the next term. So we'll start with Andy on that.
So I'll stick with administrative law. Look at the Loper-Bright Enterprise case. It's about whether Chevron, the principle that when a statute is ambiguous, a court should defer to a federal agency's reasonable interpretation, is going to survive. The context is very favorable for the challengers. Chevron's been a zombie decision for a while. The Supreme Court hasn't relied on it in years and years. And my guess is it may get its final resting place in Loper-Bright.
Melissa.
We will be talking about fewer merits cases at the end of next term. I predict the court is way behind in grants for next term. It only is granted, I think, 21 cases. It's usually 30 to 40. So it is a slow start to the term. And I don't think they're going to catch up.
Erin.
I will just note a case that I'm watching and think folks who are interested in the Second Amendment should be watching, which is Rahimi versus United States. It's a case the court took that is not particularly favorable for the challengers on the Second Amendment side, unlike the string of cases the court has taken that have been kind of affirmative challenges to state laws. This is an individual who was convicted of under a federal statute that was held unconstitutional. It's going to be a really important case for this very fast developing area of constitutional law.
And for more on a preview of next term, we have an upcoming webinar on September 15th with constitutional litigators Robert Peck and John Beisner. So I encourage all of our viewers to go to masonlec.org to sign up for the September 15th discussion that will give us an even broader preview of some of the upcoming cases. You've been watching the Supreme Court review of the October 22 term of the United States Supreme Court. We thank very much our panelists, Erin Murphy, Melissa Sherry, and Andy Pincus for joining us here today. And we hope that all of you will join us at future programming. Please go to masonlec.org to view not only that September 15th program, but we also have an upcoming program next Friday, How Little Policymakers Know About What They Imagine They Can Design, with Professors Bruce Yandel and Don Boudreau. And so we're excited about that and other programming between now and September 15th. But for those who tuned in for the Supreme Court, we certainly have more for you coming up very soon. Also, if you enjoyed this program, if you'd like to see more of these kinds of programs, please do consider contributing to the LEC at masonlec.org so that we can continue to provide this kind of educational programming. With that, I thank all of you for watching. I thank all of you for participating in this important discussion. And I think we've learned today that there's much to watch that will come from the precedent set this term, and much to watch to see how the court wrestles with the new problems and new questions that they've created as a result of this docket. So thank you very much. We'll see you all soon.